Good afternoon, everyone, and thanks for joining us. My name is Sally Guy, and I am the Director of Policy and Strategy here at the Canadian Association of Social Workers. I have the honor of welcoming you to today's webinar, and I'm so excited to say that we have two speakers who will introduce our new liability insurance brokers, BMS Group, speak a bit about how this change affects your practice, and cover some important ways to maybe reduce your risk. So beginning the presentation will be Susan Winch, who is Vice President of BMS Canada Risk Services, and she'll be followed by Andrew McKenna. He is a partner at Gowling WLG's Ottawa office. So Gowling WLG, one of Canada's largest national legal firms, they are pleased to offer summary pro bono legal advice to all social workers who are participating in the BMS/CASW Professional Liability Insurance Program. And that's just one of the benefits of choosing to be part of our insurance program with BMS. I would encourage you, if you haven't already taken a moment to read their full bios on the webinar sign-up page, I would just say to take a look at that. They do bring an incredible depth of experience and expertise to today's presentation. Before they get started, just quickly, some housekeeping items. The speakers are going to take about 45 minutes, so there will be time afterwards for a question and answer period that I'm going to be moderating. As a note on privacy, only the presentation team can actually see your name and question, so do feel free to type those in throughout the presentation. Another quick reminder, the recording and the PowerPoint, the actual slides, will also be up on CSW's website after the presentation for your access. And with those things covered, it is my pleasure to welcome our first speaker, Vice President of BMS Canada Risk Services, Susan Winch.
Thanks, Sally, for the introduction, and thank you all for taking the time out of your busy schedules to join us today. We're really excited to be your service provider on the CASW insurance program, and we're truly devoted to providing you with the quality service and care that you deserve and can expect. So today we're going to start off talking about why it's so important to carry professional liability insurance and the types of claims we're seeing with social workers. And then we'll discuss your CASW insurance program with the various options that you can purchase depending upon your needs. Andrew will follow, discussing Gowling's role with the CASW program and the services that Gowlings provide. Andrew will talk about what you should do if you receive a college complaint, the civil litigation system and how this works, as well as ways that you can minimize your exposure and possibility of having to make a claim on your policy. So the first question we should begin with is, why do I need professional liability insurance? Well, the Health Professions Act provides definitions, requirements, and expectations for your scope of practice, registration, your continuing competence, and the disciplinary process. And your college provides you with specifics surrounding your scope of practice. So to summarize a section from the HPA, as a health professional, you can be found legally responsible for the professional errors, omissions, and negligent acts associated with your practice as a social worker. You're also expected to maintain the standards of practice of the profession and practice in an ethical manner. And while we always strive to live up to our obligations and higher standard of care, at the end of the day, we're all human, and mistakes and misjudgments can happen. So essentially, the reason we all purchase professional liability insurance is to protect our assets in the event that we need to defend ourselves. By having an active professional liability policy in place, you're essentially transferring the cost of legal fees to the insurer. The insurance company will also compensate your client for the injury. So this may include medical expenses, loss of income, housekeeping and home maintenance services, as well as pain and suffering, mental anguish, that sort of thing. So there's three different types of claims that would be covered under your professional liability policy. First is a civil claim, and this would occur if you received a statement of claim from a plaintiff seeking compensation for damages. This would most likely come from a client alleging injury from your negligence due to a wrongful action or inaction, such as fraudulent billing issues, inadvertent disclosure of your client's confidential information, or failure to make the needed referral. So whether or not a lawsuit has merit, there will always be legal defense expenses incurred, simply to respond to the complaint. The second form of claim is received as a letter from your college. This is a regulatory complaint. Examples include unprofessional treatment of your client or your colleague, improper documentation or lack thereof, working outside of your scope of practice, questioning your ethical disposition, that sort of thing. And the third form of claim is alleged criminal acts, and this would be handled in the criminal court. For example, assaulting your client, which we hope won't happen. So while the insurer won't defend you for an alleged criminal violation, the policy will reimburse your legal expenses if the allegations prove unsuccessful and you're either acquitted or found not guilty. Other types of insurance claims include legal entity professional liability. So here, if your business is incorporated or if you have employees, your business may be exposed to professional liability claims, and you can protect the business name with legal entity cover. Another type of claim involves commercial general liability. For example, if your client or perhaps a courier comes to your office and slips and falls on the freshly waxed hardwood floor, or misses that step because the snow wasn't properly shoveled, leaving an icy patch, or if making a home visit and you accidentally damage your client's property. And lastly, if you have an office, you could incur flooding or a sewer backup from heavy rains, which may be very costly if you have to replace all of your carpeting, your furniture, your equipment, and any installations, not to mention the interruption to your business if you need to close down for a month due to the repairs. In this section, we're going to talk about your insurance program. So, as you can see, the CASW insurance program offers 3 different program options depending on your needs. Each option provides you with $5 million limits of professional liability cover, up to a maximum of $5 million limit per annual policy term. Excuse me. For example, if you reported 2 claims within a policy term running October 31st, 2016 to October 31st, 2017, and the first claim came in costing $2 million, this would leave you with $3 million left for the second claim within the policy term. And these limits are very substantial for the claims we're seeing with social workers. Okay, so if you're working on a contractual basis and required to carry commercial general liability in addition to securing your professional liability cover, then plan number 1 would be the most suitable. For example, if you were conducting an in-home visit and you accidentally start a fire in your client's home, the policy would defend you under your commercial general liability insurance. And if you were conducting an in-home visit and your client felt you had not responded appropriately to a crisis situation, this is where your professional liability cover would trigger, providing you with the defense. And there is no deductible for either the professional or the commercial general liability, so you wouldn't be responsible for any amount within your policy limit. The second plan would be suitable for those professionals who have their own practice and work from their office. In addition to the professional liability and the commercial general liability cover, plan number 2 provides property cover for your business contents and equipment. This includes everything from having to replace your carpet to your furniture, your built-ins and installations, should you ever incur an insured loss, such as a fire, for example. The minimum property limits begin at $50,000, but you can always purchase higher limits if needed. And all property loss would be subject to the first $500 deductible, which you would be responsible for. Also, the property cover provides extensions, and these are really good extensions. They include business property while in transit, computer equipment, professional fees, fire department charges, and business interruption. And there's actually quite a few more. I've just listed some of the main ones. So within your policy documents, this will outline all of the various extensions of cover within the plan number 2. Also note that if you do have a business, you can extend your individual professional liability cover to include the business name. So you can be sure that if a client takes action against your employee or yourself, they will no doubt list your business entity within the action. So if you have up to 2 employees, the additional premium to cover your legal entity would be $100. And if you have more employees, this would be referred to the underwriter for pricing. Also note with plan number 2, the commercial general liability portion will protect you if you accidentally start a fire and burn down your leased office unit. In this instance, your policy would indemnify the landlord for his or her interest in the space, as well as any damage that you cause to the neighboring units occupied by other tenants. The third plan, plan number 3, is designed for those social workers who do not have an office to insure and are not required to purchase commercial general liability cover. So most often you would be employed in the public sector, hospitals or schools, whatnot, or by someone in the private sector. For example, if you were providing e-counselling services, that is by Skype, telephone, online, or video conferencing, that sort of thing, cover would extend worldwide as you're providing the service from here in Canada. So the policy would cover you if a client from another country brought action against you, but remember, you need to bring the action back to Canada or the U.S., or they would need to bring it back to Canada or the U.S. If the online client is from Germany, for example, the policy would not respond if he or she filed an action against you in Germany. The injured party would have to file the action against you in Canada or the U.S. for the policy to trigger and respond to your defense. And remember, the policy protects you with defense costs and damages for injury that you may have caused to your client, such as bodily injury, sickness, shock, mental anguish, mental injury or disability, that sort of thing, as well as an error or an omission of professional services, such as misguided professional judgment. So we spoke earlier about regulatory legal expense cover, and with all 3 options, you would have up to $200,000 per annual policy term for defense cover should a complaint be lodged against you at the college. Similarly, with all of the options, you would have $150,000 limits available to reimburse you for criminal defense expenses once you're acquitted or found not guilty. So this is the end of the insurance portion of the presentation, and we'll now turn over to Andrew McKenna, partner of Gowlings, to discuss the legal issues.
Thank you, Susan, and thank you, Sally, for your introduction. As Sally mentioned, my name is Andrew McKenna. I'm a partner at the Gowling WLG office in Ottawa, and I'm a member of the team of lawyers who act for various healthcare professionals, including social workers, with respect to regulatory claims as well as civil claims. And I wanted to talk to you a little bit today about what Gowlings can do for you, what we do and what we can do for you, and then take you through the process on a very high-level basis of what you need to do if you receive a complaint. Because as I will note later on, complaints to your regulator form the majority of the work that we do on behalf of members. So Gowling WLG is a national Canadian firm, and in fact we are an international firm, but in Canada we have offices in British Columbia, Alberta, and Ontario and Quebec. We have about 700 lawyers across Canada. The program is run out of Ottawa, and we have a team in Ottawa that does that, but we also have lawyers in BC and Alberta and Quebec who act for members when appropriate. We've been doing work for healthcare professionals for a very long time, certainly longer than I've been at the firm, and we've established a good working relationship with BMS and with the insurer to ensure that quality services are delivered consistently. So in terms of our approach to this program, we really have two roles. First, and our primary role under the program is to ensure that members receive a quality defense, whether it's a complaint before the college or as a defendant in a lawsuit. And neither process is more important than the other. A college complaint can be very stressful, very involved, and can have serious implications on your practice, and that's why they need to be treated seriously. Obviously, a civil claim, as Susan's already mentioned, is when you're sued for compensation, and that process needs to be taken seriously as well. So we will guide you through that process if you're unfortunately named. But our second role, and we take pride in that, is to work with the CASW, BMS, and your insurer to provide risk management strategies to reduce and minimize the possibility of loss in the future. And we do that in a number of ways, and I'll touch upon that. But we prepare articles, for example, based on what we're seeing in the profession through publications, etc., that we're seeing, but as well as the issues that we're seeing from complaints that are coming in, files that we're working on, but as well as calls we're receiving on the pro bono hotline. Because we operate the hotline nationally, we keep track of all of the information that comes in, and over the course of a year, you can imagine we receive many calls, and we're able to determine based on those calls what the relevant issues are, what things are of concern to members. And based on that, we'll go back to the association, we'll come to BMS and say, we're seeing a lot of calls on this issue, maybe we need to do an article. And so by that, we're hopefully providing education to members to say this is an issue which seems to be of concern, here's the things you can do to deal with it. So that's the dual approach we take with respect to these files. In terms of our formal involvement in a matter, that is triggered by the reporting of a complaint or of a civil action. So if you receive a letter from your college telling you that you've been subject of a complaint, or you're served with a statement of claim, or even if you know a statement of claim is coming, you may, the clinic you work for or the institution you work for may have received a copy of the claim, but the process server has not yet been able to serve you personally. As soon as you become aware of that, you should be calling your insurer. A lot of members will call the hotline, and that's fine, but when you call the hotline, we will tell you you need to call BMS, and they're going to get you set up with your insurer. Because once the insurer is on, coverage is triggered, and they assign legal counsel, and then we can start working on your behalf from that moment forward. So once the call is made to your insurer and coverage is triggered, a lawyer will be assigned from Gowlings if the action is in Ontario, BC, Alberta, or Quebec. If it's not, if you're in another jurisdiction, then we have firms in each province who we go to take on those claims. And we only have one firm per province that does the work because this type of work is specialized, and we want to make sure that we have people that are doing this work that are familiar with the process and can provide you with a superior defense. So you will be put in the hands of counsel who do this work as a primary part of their practice. Once the file is assigned, someone from the lawyer who's assigned will be in contact with you, and our goal is to do that within 24 hours. Now, I'll use the word assigned carefully here because you may make a call to BMS or you may speak to the insurer. We have to wait as counsel for the insurer then to contact us. So it may be a few days between the time that you talk to BMS and the insurer actually signs the file to us. But once we get it, we will be in contact with you as soon as we can. And then once we're in contact with you, you don't have to deal with the lawyer if it's a civil action, or the college for the most part if it's a college complaint, because we will be doing the interaction with the college or the lawyer. So that's the general process, and with anything, there's always exceptions and there's always nuances that we have to be aware of. And one of the things I hope we'll cover some of those is by taking you through the complaints investigations process. I'm going to spend more time on this process than I am with respect to civil claims because, quite frankly, most of the work we see is in the complaint realm, and that is concerns raised with your regulator regarding care and treatment you've provided to a client. So every province has a regulatory scheme in place that gives the regulator broad powers to investigate complaints. The territories, the only one that I'm aware of that has a scheme in place is Northwest Territories. The Yukon and Nunavut do not at this time, but that then is assumed by the government through the applicable legislation. The powers the regulators have are quite broad and need to be taken seriously. Anyone can file a complaint. It doesn't have to be the client or the person you provided treatment to. It can be somebody associated with that person, family member, a friend, or it can be one of your colleagues if they see something that they think is inappropriate, or your employer can make a complaint. So it doesn't have to be from a client, although most of the complaints do arise from that relationship. And as the next point says, most complaints arise from interaction with clients, but they can also arise from non-interactive activities as well. Complaints can lead to a broader investigation. And again, all of these comments are made in a general nature. I would invite you to consult with your regulator's website to review the process as it relates to you. I'm going through the generals here because each province has a similar type of setup. But complaints can lead to a broader investigation. For example, a complainant may raise an issue about a certain aspect of your practice. The college receives the complaint. You deliver your records, and the records are difficult to read, or there's deficiencies in your record keeping. That may lead the college to want to look at your practice in a broader sense, to pull a number of charts from different clients to see if the record-keeping deficiencies in that one chart are something that is consistent through your other charting. So there is always that possibility. As well, a college has an ability to start investigating you on a matter that has not been complained of by the complainant. And again, based on what you put in your response, the college may see a red flag and want to investigate something else. I can tell you in the last year, I've had 2 files where in the course of our response, the registrar of the college became concerned that a mandatory report had not been made under the Child and Family Services Act in Ontario. This wasn't the focus of the complaint in either matter, but as a result of the member's response, a further investigation was started. So that just gives you an example of the broad nature of what the colleges can look into. The last point is hopefully the one that you take away from this. Regardless of whether there's any merit to the complaint, you have to treat it seriously. The colleges are under an obligation to investigate complaints, so they have to be seen as taking it seriously, and you have to take it seriously, regardless of what you think of it. If you are subject to a complaint, there is a chance it's going to be a frivolous complaint. It may be somebody who's just disgruntled and is trying to exact some sort of retribution for what they see as deficient care. Regardless of what you think of the person or what you think of the complaint, you need to treat it seriously and respond accordingly. So if a complaint is filed against you, you will be notified of the complaint, and that's typically by way of letter. On the odd occasion, you may get a call from the college, from the investigator who will want to talk to you before you receive notice. But the usual practice is to get a letter from the college telling you, we've received the complaint, here it is, and we're going to need a response from regardless of the nature of the complaint or how the college is investigating the matter, you are going to be given an opportunity to respond. You will have your opportunity to tell your side of the story. So when you get that notification of a complaint, I would strongly encourage you to contact BMS, as you may have coverage to have a lawyer assist you with the matter. It may seem like it's a straightforward complaint and it's easy to respond to, but at a minimum, you may want to talk to a lawyer first before you go through that process. It's something you have coverage for, so you may as well take advantage of it. What may seem like a simple matter to you may have different consequences or ramifications for the college, and they may take it a lot more seriously than you may think it is. So there's no harm in getting advice as to how to prepare your complaint or your response to the complaint. We've been doing this for years, and we know there's a certain way that the college likes to have a response to a complaint, what things they like to see, and more importantly, the things they don't like to see. And there's no harm in seeking out legal assistance. In this day and age, your regulator will assume that you're going to seek out legal assistance when you receive a complaint. So, as I said, take advantage of the fact that we are here to assist you with that process. There used to be a stigma, some people thought there was a stigma attached to getting a lawyer involved, that automatically led to the conclusion that the matter was more serious than you thought, and that's certainly not the case anymore. And in our experience, some colleges are actually telling you to call a lawyer and get some assistance. So when you receive notice of the complaint, if the complainant has provided any documentation along with the complaint, you will get that. So you will be given an opportunity to see everything they have provided. And that's because you're entitled to have a full appreciation of what the allegations are against you. So the complaints process itself is a paper-driven process. So your response is the primary document that's going to be used to assess the validity of the complaint or your response to the complaint. There's no opportunity to provide testimony before the committee that's going to ultimately make the decision. In most cases, there's no interviews that take place. It's simply in writing for the committee to determine. So in terms of responding, you need to set it out in a clear and concise manner, your position and why you disagree with the complaint. Now, there may be issues that are raised in the complaint which you agree with, and there's certainly no harm in conceding that when you do respond to the complaint, because many colleges appreciate insight and accountability from their members. So that's one of the reasons why getting legal advice is important, because if there's an issue which you can concede on, then we can craft it in a way and respond to the college in a way that will address its concern and show them that you are taking things seriously. When you're preparing your response, make sure you've reviewed everything before you go through that process. If this is a lengthy period of treatment that you've provided to the client, then you need to go through those records to bring yourself back up to speed on what happened with that client. If there are guidelines that you're aware of from your respective regulator that you need to review, go ahead and do that. Our process is to have you prepare the first draft of your response, and really that response is a factual summary of what occurred and your views on the allegations that have been made. Once we have that document, we take that and turn it into a response that's in the form that the college likes. So we will add information, we will edit and modify where necessary. When you're doing your response, you're going to have a period of time to do so. The typical period is 30 days, but most of the colleges are willing to grant extensions as long as you ask for them in a reasonable amount of time and you're not looking for a lengthy extension. But the colleges appreciate that it's going to take you some time, especially in the case of somebody who has written a 21-page complaint which covers off years and years of treatment. If there are references in the patient chart, we make reference to those. If there are things you want to draw to the committee's attention, you need to do so. You can't assume that the investigator is going to read everything and pick up on all of the issues which are important for your response. So you need to lay it out for the investigator and for the committee. And I realize I've been using committee and investigator interchangeably here, so let me just take a step back. When a complaint is received at a college, the college will assign an investigator. Every college has a team of investigators that deals with complaints. That investigator is tasked with gathering all the information that's relevant for the complaint. And once the investigator has gathered all of the information, the file then is sent to the complaints committee of your regulator. And that committee is composed of members of the profession and in some cases, a member of the public. That committee will consider the entirety of the record and then come up with their decision. So that's the difference between the investigator and the committee that I've been making reference to. If there is an issue with your charting, for example, so you've received the complaint and you realize you forgot to note something or something is set out which is incorrect, you cannot amend or alter your record. There are guidelines, obviously, from the college as to what to do if you have an issue with your record keeping, if something needs to be added. But if you try to do something after a complaint is filed, it's going to look, it's going to be viewed upon as a negative by the college. So the record is what it is, and we can deal with it in our response. The other piece of advice in terms of responding is that you should not continue to treat a patient after a notice of complaint is received. Common sense would say that if a person has complained about the care and treatment you provided to them, there's been a breakdown in the relationship with that individual, and it would not be appropriate for you to continue treatment. There are obviously exceptions to this in emergency circumstances, but there is nothing wrong, and in fact, as I said, you should be doing this in terminating the relationship in accordance with the guidelines that your college sets out, making sure that there's a continuation of treatment for this individual going forward. Once your response is complete, we'll provide it to the college, and that response is usually provided to the complainant. There is an opportunity for you to make submissions that the response and or any records you send should not be provided to the complainant. And we see this in cases where there may be information contained in the notes that, if seen by the complainant, may cause further harm to them. It may trigger an emotional reaction. And so the college is sensitive to that and will consider those submissions. The default position is to let the complainant see your response so they can provide further response. But we've had cases where the college hasn't provided the response, or they've asked us to prepare a very high-level, general summary of our response so that the complainant can have that and have a sense of what we responded to without going into any details. The usual practice is not to provide any records, though, that you've appended to your response, unless you specifically want them to go to the complainant. In many cases, if the complainant delivers further submissions in response to your submissions, the college will give those to you and give you another opportunity to respond if there are further comments that need to be made. And sometimes a complaint that is made initially is very general in nature and doesn't have the specificity that we would like. When the complainant sees your response and specifics in there, that may trigger them to recall other things or make further allegations. So you will have an opportunity to respond. The investigator itself may want further information from you. There may be questions that they have that are not addressed by your response, and they may follow up and say, can you let me know what your position is on this, or can you let me know if you did this, or I think this guideline is relevant here. Could you tell me what your view is on the applicability of this guideline to what happened in this case. So there may be a request for further information. The investigator may look at other records. They may want to talk to other people. They're going to try and gather all the information they need to be able to determine what the outcome should be. And if there are people that you think the investigator should speak to, perhaps one of your colleagues, perhaps a staff member in your office, we invite them to do that. In most cases, we'll get a written statement from them and include it, and we'll have talked to them already, but certainly we will invite the college to do that because we want them to make sure they've got all of the relevant information. You need to make sure that your response is courteous and professional. It's human nature when you're alleged of negligence or deficiencies in your practice to be defensive and to want to criticize the complainant. And we've all been there, but that's not the approach you can take in your response. You are seen as the professional, and your college expects you to respond in a courteous and professional manner and not engage in the same type of language or accusations that the complainant may have set out. Once the regulator has all of the information it believes is necessary to consider the matter, then it will be sent to the complaints committee. And there are various outcomes that can occur, and I will reiterate my point that you should consult the website of your regulator for further details. But some of the common outcomes you can expect, and the one we're always hoping for whenever we get a complaint filed is to take no further action. The complaints committee has reviewed the matter and does not believe that there are any concerns that need further action by the committee. The file is closed, and nothing further happens as far as the college is concerned. You can be asked to appear before the complaints committee to be cautioned. So the committee did have concerns about one or more aspects of the interaction you had with the patient that they need to let you know about, and that's done by way of a caution. So it's not severe enough to warrant a referral to the discipline committee and allegations of unprofessional conduct, but certainly something that you need to be aware of. There can be an educational disposition, so the college is concerned about your record keeping, for example, and they want you to take a record-keeping course or work with somebody to get some coaching to assist you with your record-keeping. And that's set in for a period of time, and they may want to come back and reassess your practice down the road. Or they may think your knowledge in a certain area is lacking. And again, they'll want you to bring yourself up to date. In the more serious cases, there can be a referral to the discipline committee, and the discipline committee is a separate committee of the college. And that committee is there to determine whether there has been professional misconduct by a member. And that's obviously, in terms of conduct, that is the most serious step a committee can take. If there's a referral to discipline, that does not mean that a decision has been made. It's simply the complaints committee saying, we're going to defer this or send this on to the discipline committee for consideration. And there's a whole different process that the committee goes through, and I'm not going to talk about that today. But we are there to assist you through that process. And finally, if there's any issues with your ability to practice, you can be referred to a committee to determine whether you are competent to practice. Sometimes we have members who are having addiction issues or mental health issues that raise the question of whether they should continue to be providing care to patients. So those are things we can assist you with. Now, I'm going to touch very briefly on civil liability, and I'll touch on it because it does happen from time to time, but as I said, we don't see a lot of this. The civil litigation system in each province differs, but there are some common traits. Susan already talked about being served with a statement of claim, and that's common in every province. In order to start an action against a social worker, there needs to be a statement of claim filed. If you deny the allegations, then a defense is going to be prepared, and it's another document which gets filed with the court that says, I've received the claim and I deny the allegations, and here's why I deny the allegations. And then there's a litigation process that we have to go through. The take home from this is it's a long process. Cases can take 2, 3, 4 years to work their way through the system. Most cases they get started don't make it to trial. I think the stats in Ontario are about 97% of cases that are started do not make it to a trial. They are resolved in one fashion or another prior to going to trial. And that you definitely need legal assistance to guide you through the process. And again, this is something your policy responds to. So don't try to go through the legal process on your own. It can be an intimidating process and an overwhelming process, and this is why we're here to assist you. The other takeaway from a civil claim is that in Canada, if you were sued for negligence, and not all the cases we see are for straightforward negligence. We have cases of defamation, for example, or breach of contract. But if it's a claim in negligence, meaning the patient, the client, has said that the services you provided fell below the standard of care, then in order for them to prove those allegations, the plaintiff must obtain an expert opinion. The court can't make this determination on their own. They must get an opinion that states you fell below the standard of care and that your breach caused or contributed to the damages sustained by the patient or client. So it's a high threshold to meet, and it's essentially one of your peers has to review your role and say, if it was me or any reasonable social worker would have done the following in this situation, and I don't think what the social worker did here was appropriate. Hopefully the social worker that gets retained is going to say the opposite, that all the care was sufficient and met the standard. But the plaintiff has to have that type of evidence. Just in terms of dealing with or minimizing risk, I'm going to talk about the pro bono hotline here in a second, but just a couple of things that you can implement in your practice without having to do too much is obviously make sure you're up to date on your continuing education. Most colleges are now relying heavily on their website to an email to communicate updates to guidelines, policies, bylaws. Don't ignore that stuff. The college does take it into account, and in a lot of cases, the college can actually track when if they're sending you emails with information, whether you're actually opening that email and reading it. So keep up to date on that. It's a good, easy source of information. Record keeping is vital. Paper is a lawyer's best friend, and taking good, clear notes is always going to be helpful if you're ever called upon to justify decisions you've made, care you've provided. So I can't stress the importance of good record-keeping practices enough. And in a lot of cases, it's the difference between us getting successful resolution and not. For example, consent is a classic example. You may, by practice, have a consent discussion with every one of your clients, but if you don't document it, you're going to have a hard time proving that you did have a discussion if the patient or client denies that such a discussion took place. So good record keeping is key. And the third, and this leads me into talking about the pro bono hotline. If something happens, call the pro bono hotline. The pro bono hotline is something that our office administers. So it's for professional liability questions only. So we don't give family law advice or employment advice. It's related to issues that arise in your practice as a social worker. But if something does happen, call the hotline. The number is here, and I know it's on the website as well. In addition to our service, there's other sources you can go to. The website of your provincial regulator, which I've talked about. There's also practice advisor at most colleges. We would say use that for general questions. You don't want to get into specifics because we've had cases where somebody's gotten into specifics with a practice advisor and then next thing they know, they've received a letter that the college has a concern about their practice. So if you use that resource, use it cautiously. And then, as I said, the pro bono line is there for you to utilize. And how it works is you make a call. You're going to get a voicemail. You won't get somebody immediately, but you'll get a voicemail. And we have somebody in our office take down the message. A note goes out. There's a lawyer assigned each day. You will get a call back within 24 hours. And I apologize for the delay there. I just lost my slides, but I will keep going and hopefully you can hear me. You will be called back as soon as possible. It's usually the same day, but there may be situations, i.e. if you call late at night or on the weekend, you're not going to get called back until the next business day. You get half an hour of legal advice, and in a lot of cases, it doesn't take half an hour. You may have a specific question that needs to be answered, and our lawyers will do their best to provide you with advice that is helpful. Many of the calls we get relate to, this just happened, what should I do? And in those cases, we can provide you with some guidance as to what you should be doing in that situation. Taking notes, making sure that certain steps are taken. So don't worry about the type of question that you have. There are no stupid questions for the hotline. We do this every day as a living, but you don't typically have to face legal issues on a daily basis, so please don't hesitate to use the hotline. That's what we're there to do. And if it requires further involvement by us, then we can make arrangements to do that. So that's a lot that I've covered in half an hour, and you may have questions, and we'll certainly be open to those. But those are my comments about our program and how we approach the legal services we provide. Thank you for your attention.
Well, thank you so much, both of you, Susan and Andrew, for that incredibly informative presentation. It's so important. It's something that touches on, every social worker and their practice, so huge thanks for that. I did notice that we had a few people tapping in after the introductions were complete, so just one more time who those speakers were. We had Susan Winch at the beginning, who is Vice President of BMS Canada Risk Services, and then following that we had Andrew McKenna, who is a partner at Gowling WLG's Ottawa office, Gowling being the one of Canada's largest national legal firms that offers the summary pro bono legal advice to anyone that's a part of our liability insurance program. And so just one more time, that is free legal advice that you can have access to if you are part of our program with BMS. So yeah, do use that. I also just want to address a few of the questions that are coming up over and over. One, just housekeeping-wise, yes, this recording, so the audio and the video, as well as an actual PowerPoint of the slides, they are going to be available on the CASW website, imminently, about a half hour, probably after the presentation. So do look for those if you want to share this with any of your colleagues. The other thing that I want to just quickly address too is the fact that we're getting a mix of questions. Some of them very broad, which are the ones that I'm going to ask Andrew and Susan today. Some of them are more specific, sort of about your specific practice, the environment you're practicing in, which plan would be best for you in your specific practice milieu. And so I was wondering if I could just get maybe Andrew to comment on the fact that on the importance of actually getting individualized advice. So, at CSW, we get people calling in all the time asking these types of specific questions, and I always sort of say, I can give you sort of basic recommendations based on the Code of Ethics or based on what I know from my informal conversations with lawyers and things like that. But Andrew, I'm wondering if you'd care to elaborate a little bit on sort of the importance of that specificity.
Yeah, I mean, the advice that we can give you is limited to the information you give us. So certainly when you call I'll use the hotline as the example. When you're calling the hotline, it is vital that you give us as much information as you can about the situation, because you can either give it to us, or the lawyer who you're speaking to is going to start asking you questions to try and narrow it down. Because I talked today in very general terms about the process, but there are lots of exceptions to almost every statement I gave you, depending on your particular situation. So if you have an issue that you want to talk to a lawyer about on the hotline, I would encourage you to take a moment, make some notes, and make sure that you've got all the details that you need to relate to the lawyer. And I appreciate you may not know, you may not appreciate that a certain detail is important, and the lawyer will ask you that. But if you can have a chronology of what's happened, who was involved, etc., that will assist us in giving you the best advice we can. Because as I said, the advice we can give is limited to what you tell us. So that I think hopefully addresses your comment there, Sally.
No, that's super helpful. The other thing I'm getting here is people asking whether this hotline is available to all provinces. And yeah, the only requirement to get access to the hotline is being part of our insurance program. If you want to learn more information about how to sign up for it, if you are not already part of it, you just head to our website, and it's listed under member benefits. So just or type into the search bar liability insurance or the word BMS. And you can access it. So
sorry,
with that said, I'm going to move on to... Sorry, yeah, go ahead, Andrew.
Sally, if I could add there. We have lawyers in every province that deal with the handle the hotline. So if you're calling in Ontario, you will hear from somebody from the Gowlings Ottawa office. But if you're calling in Saskatchewan, there's a firm in Saskatchewan. We have a lawyer there who deals with all the hotline calls. So you will get a call back from somebody in your province or territory, for that matter.
That's great. Specific is always better. I think people on the ground in the province know what might be something special about that province or something. So I think that's even probably better than having one that operates nationally. Here's a question that we get a lot actually here, which is and it's sort of a case study. I work for the provincial government, and I'm pretty sure that I'm covered by their insurance in the event of an incident. Do I still need to be a part of a program like this?
Right. Actually, that's a great question, and I'm going to advise that yes, it's a really good idea to secure your own professional liability insurance. And the reason being, in the event that both you and your employer are named in an action, your employer's policy will have the defense, will have the cover, will defend both you and the employer. However, there may be a point in the defense where there's a conflict of interest. So, for example, especially if you may be responsible for the suit coming forward. And in that case, the employer's policy will obviously move forward in the interests of the employer. So really, it's a good idea for each individual professional to have their own professional liability insurance. That way, your policy is working only for you with your best interests, and you don't have to worry about any conflict with your employer when they truly need to defend the business. So that would be my advice for sure.
Thank you, Susan. Another question that just popped up here is, are there any circumstances under which a social worker would not be able to have a lawyer or access a lawyer for help with regards to a complaint at the college?
Sorry, I'm trying to think of the circumstances where that would take place. In my experience, if you have a complaint to the college, the insurer will, the insurer has to make the decision as to whether coverage applies or not. But if it's an intentional act, I'll use an easy example. If there are allegations of sexual abuse, boundaries violations, then my experience is that the insurer will protect their rights by issuing a reservation of rights letter. So they'll say there is coverage for now, and the lawyer can handle your defense. But if there's a finding against you of sexual abuse, then we reserve the right to withdraw coverage, and you're going to be responsible for paying those legal fees. So there is that situation that does arise. But if a complaint is made to your professional regulator about something you did in your practice, then and I can defer to Susan here, but the insurance policy typically responds to that complaint. But there may be circumstances where at a later time the insurance company decides, because of the nature of the allegation, and it's usually intentional acts, which would fall outside the scope of you practicing as a social worker. And I just said sexual abuse is the obvious one, or any type of criminal act.
Yeah, that's pretty clear there, I think. Absolutely.
Okay, great. This one is really quite broad, but I think very much of interest to all social workers. What is the most common complaint or common type of complaint you see against social workers that ends up leading to legal action?
Well, I'll speak to the common complaints we see that lead to complaints at the college, because I think that's the primary way we get involved. Communicate, and I'll use this generally, communication or miscommunication. It's amazing how many complaints start because there's been a breakdown in communication between the member and the patient. Somebody's taken something the wrong way. Somebody hasn't been transparent. So communication issues are usually the root of many of the complaints. But in terms of common complaints, consent issues or lack thereof of giving consent to disclose information, disclose records. Appreciate family law disputes are something which come up frequently, and where we have parties fighting over custody, etc. The issue of consent comes up often, or whether certain information should have been disclosed. Breach of confidentiality is another one which we see regularly. Goes to records being disclosed or personal information being disclosed inadvertently. Patient files on a USB stick that were lost, that sort of thing. Boundaries, certainly in the social work profession, there is obviously in any healthcare profession, but social workers, there's a higher degree of sensitivity to this, but boundaries issues with clients. And not simply of a sexual nature, but just simply crossing that line between a patient and something more than that. Mandatory reporting is an issue, and if you look at the Ontario College's website, there were a couple of cases last year that went to the discipline committee on mandatory reporting issues. One for the failure to make a mandatory report, and one for the fact that a mandatory report was made and it likely shouldn't have been made. So, and there are changes coming in Ontario through Bill 87. It's something that's likely going to be in place by next year, which are going to change some of the issues that the colleges are dealing with, but there's discussion about increasing fines for mandatory reporting, etc. So, or failure to make a mandatory report. So that's there. I guess the only other issue is acting outside of what you're qualified to do, or not qualified to provide certain services to a member. So I'm talking in generalities there, but that's generally the nature of what we're seeing in terms of complaints and issues that are drawing the regulator's attention.
No, I think that's a super helpful answer, even if it is just broad strokes. I'm going to ask two questions that we get asked a lot, and that we're getting asked a lot on today's question and answer feed. I do some counseling via Skype to people who aren't in my province. Am I eligible for this coverage? And very much related to that are people asking, I do actually all of my counseling via the telephone. Am I a fit for this program?
Okay, I'll answer that one. Yeah, absolutely. There is definitely cover for e-counselling. Cover is extended on a worldwide basis. So as long as you're here in Canada, working from your office, providing your Skype or whatever e-counselling services, there is worldwide cover. However, if a suit is being launched against you for alleged injuries of some form, the plaintiff needs to bring the action forward to Canada or the U.S. If they're in another country and they file an action against you in their country, except if it were the U.S., of course, the policy wouldn't trigger. So they would need to file in Canada or the U.S., and your policy will respond. Yes.
Okay, that's great. And then another one here about sort of a specific type of coverage, which is I saw that there is an additional fee for cyber coverage. And could you tell me a bit more about this category and why I might need it?
Right. Okay. Absolutely. If your computer or server has been compromised with malware and your client's confidential information has been exposed, you would be liable to all of your clients for breach of privacy. And so we have a little brochure here. It's on cyber and privacy liability. And it's $75 per member. And then if the business requires cover, pricing is contingent on the revenue bands. But I'll just go over it briefly so you can get an idea of how it works. Cover provides a $1 million limit for information security and privacy liability. So, for example, legal actions against you for unauthorized disclosure of your client's private information. Liability for failure to prevent the loss. So if you have inadequate firewall protection, which allows the virus to come through. The cyber and privacy liability also provides $250 limits of regulatory and defense expenses for costs involved with the regulatory proceedings, such as the defense or the penalties if they're awarded against you. It also includes notification expenses within the $1 million limit. This includes cost to hire an expert to determine the cause of the breach and the compromised data, which is usually credit card information most often. Also, legal fees to determine what action is required per the privacy laws. Costs to notify the affected individuals. And on a file basis, that can get quite expensive. So if you have 1,000 files or 1,000 clients, that can be quite expensive. So, and $250,000 limits to hire a PR consultant to mitigate any reputational damage. So lastly, the cover provides $1 million limits of website media content liability. So this is your liability for wrongly violating one's right to privacy, maybe by posting undisclosed information on your website, wrongly disparaging an individual on your site, or wrongful use of plagiarism, piracy, breach of copyright, and misappropriation of ideas, that sort of thing. What is excluded, you should make note of this, is that liability from the loss or theft of data on your USB stick or any other portable device such as your laptop or your iPad, unless the data was stored in an encrypted format, so passcode protected. And I went through the pricing. So for all of that, it's actually really smart cover to have if you're able to secure that. So it's very, very comprehensive, and we're really pleased to be able to offer that now. Yeah.
Well, I am noticing that we are out of time, and I apologize if I wasn't able to get to your question. So I do have to wrap up now by saying a huge thank you again to Susan Winch and Andrew McKenna, who presented for us today on BMS Group. If you want to learn more about the BMS/CASW liability insurance program, if you're not already a part of that program and you want to get more information about it, just head to our website, casw-acts.ca, and you can search just for the word BMS or the word liability insurance, or it's available under the drop-down menu under member benefits. In the same vein, the PowerPoint and recording of this presentation, it will be available on our website very shortly. And for those of you who need confirmation of your attendance at this webinar, it can be downloaded by clicking on the yellow icon, which is the rightmost icon at the bottom of the window that you're watching right now. So if you log back in using the same link that you used to get this presentation in a few hours, that'll be available for you to download as a PDF. Finally, I would just thank you in advance for taking a few minutes to complete the short survey that's going to pop up afterwards. It's going to help inform our future continuing education opportunities. Thank you all again so much for attending, and again to BMS Group and our presenters for their time and expertise, and all of you have a great rest of your National Social Work Month. Thanks.
Thanks, Sally.
Thank you.